Good morning, class. All right, settle down, everyone. Welcome KSLU LLB students to this mandatory exam preparation lecture. Today, we're taking a microscopic, highly structured look at Family Law 2, specifically the Muslim law of wills, or Wasiyat. So, put away those distractions, take out your notebooks and your pens. This explainer is designed with one absolute purpose, okay? To ensure you understand the legal principles profoundly and, more importantly, reproduce them flawlessly in your final examinations. We'll rely strictly on the legal literature presented, so pay close attention.
Here is our framework for today. 1. Introduction and Wasiyat definition. 2. Essentials of a valid will. 3. Kinds of Muslim wills. 4. Limitations on testamentary power. 5. Mandatory case law analysis. And finally, 6. Will versus gift distinction. Let's get straight into it.
Section 1. Introduction and Wasiyat definition.
This is your very first crucial heading. And listen, structure is everything in KSLOE exams. If you present this clear framework to the evaluator, you're setting yourself up to score a full 16 marks. Now, under Muslim law, a will, or wasiyat, is a declaration by a Muslim to dispose of his property after his death. Unlike gifts, known as Hiba, a will operates only after the death of the testator and is subject to strict limitations to protect the rights of legal heirs. Note this down right now. The absolute most important exam point here is that a wasiyat operates exclusively after death. If you confuse this with a hiba, which is an immediate transfer, the examiner will literally stop reading. You must aggressively emphasize this distinction in your introduction.
Moving to the formal definition. Definition of will, or wasiyat. A legal declaration of the intention of a Muslim regarding the disposition of his property after his death. I want you to memorize this exact phrasing. No paraphrasing, and definitely do not use your own words. You begin your KSLU exam answers perfectly with this definition, word for word. It establishes immediate academic authority.
Section 2. Essentials of a valid will.
I remind you, students, underline this major heading in your answer script. A clear layout literally guides the evaluator's pen to give you maximum marks. Let's dissect the required legal competencies. Point 1. Competency of Testator, must be major, of sound mind, must act voluntarily. Point 2. Competency of Legatee. Any person capable of holding property can be a legatee, which includes a minor and a non-Muslim. To elaborate on this, the giver of the wasiyat, the testator, must have absolute legal capacity. A sound mind and voluntariness are completely non-negotiable. But look closely at the receiver, the legatee. The law is incredibly broad here. Even a minor or a non-Muslim can be a valid beneficiary. Ensure you highlight this stark contrast in your answer.
Continuing with the essentials. Point 3. Subject matter must be property owned by testator, transferable property. Point 4. Consent, required in certain cases. Point 5. Form of will, can be oral or written. No formalities required under Muslim law. Okay, pens down for a second and listen to me. Point number 5 is a very common trick question from KSLU evaluators. Unlike other personal laws, Muslim law does not require a will to be in writing, nor does it require attestation. An oral declaration is perfectly valid if it can be proven. You absolutely must explicitly state that no formalities are required. Do not fall into the trap of applying the Indian Succession Act here.
Section 3. Kinds of Muslim wills. You need to guide the examiner through your essay by keeping your formatting clean and precise. The kinds of wills are conditional will, contingent will, and joint will. Now, I'm instructing the class right now to write these down as clean, distinct bullet points on your exam sheet. Please, do not write them in a messy block paragraph. Visual clarity directly translates to marks. A conditional will depends on a specific condition, a contingent will depends on an uncertain event, and a joint will is made by 2 or more persons together. List them clearly just like that.
Section 4. Limitations on testamentary power.
I need your utmost attention right now. This is the absolute most important, high-scoring section of your exam answer. This is exactly where you prove you understand the strict limitations protecting legal heirs. Rule 1. The 1/3 rule. A Muslim can dispose of only 1/3 of his property by will. The remaining 2/3 must go to legal heirs. The exception can exceed 1/3 with the consent of heirs. Class, this rule is the absolute mathematical cornerstone of Muslim testamentary power. You cannot simply will away your entire estate. The law fiercely protects the natural legal heirs. You must state clearly that mathematically, 2/3 is locked for the heirs, unless an explicit exception is triggered.
The limitations continue. Rule 2. No will in favor of heir. A will in favor of a legal heir is not valid. The exception.
It is valid if other heirs consent. Rule 3. Consent of heirs. Consent must be given after the death of the testator. Prior consent is not binding. Let's carefully dissect this mechanism of consent. Consent is literally the only mechanism to bypass these strict limitations. But here's the critical legal nuance. Prior consent, given while the testator is still alive, is legally void. Why? Because an heir's right only arises after the testator's death. You must stress this temporal requirement in your exam. Make sure they know you understand consent is only valid if given after the death of the testator.
And the final limitations. Rule 4. Bequest must not be uncertain. The property must be clearly identifiable. Rule 5. Cannot defeat mandatory heirship. A will cannot override fixed shares under Muslim law. I'm warning you, students. KSLU examiners will deduct marks if mandatory heirship protection is not explicitly mentioned. A will is not an instrument to cheat rightful heirs out of the Quranic shares. Write this down and underline it twice.
Section 5. Mandatory Case Law Analysis.
I demand your absolute, utmost attention for this part. Without citations, your answer is just a generic essay. Case laws are exactly what secure that top bracket of marks, so we're going to break these down deeply. The Privy Council upheld the 1/3 limitation, emphasizing protection of heirs' rights. That is from Ghulam Muhammad v. Ghulam Hussain. I instruct you to draw a physical box around this case name on your exam paper. Do not just drop the name and move on. Explain the background. In this case, there was a dispute where a testator attempted to bequeath an amount that significantly exceeded the legal 1/3 threshold, effectively bypassing the natural heirs. So, what was the verdict? The Privy Council struck it down, holding that without the explicit consent of the heirs, any bequeath beyond 1/3 is completely legally void. The absolute relevance of this case is that it firmly cements the 1/3 rule as binding law, not just a casual guideline. Box the case name and explain it thoroughly.
Next up, we have Abdul Manan Khan v. Murtuza Khan. The court held that a will in favor of an heir is valid only with consent of other heirs, reaffirming restrictions on testamentary power. Underline this citation in pencil to instantly prove to the evaluator you understand the strict exception. The facts here are vital. A father executed a will leaving a disproportionate amount of his estate to one specific son, effectively cutting out the other siblings. The court's ratio decidendi was crystal clear. You cannot show preference to one heir over another through a will without the consent of those who are being disadvantaged. The verdict struck down the preferential will because the other heirs did not consent after the father's death. The relevance here, it rigorously protects mandatory heirship against internal family favoritism. Underline it, folks.
Section 6. Will versus gift distinction.
Let me be perfectly clear. A comparative analysis is the absolute best way to conclude a 16-mark answer script. It shows immense analytical depth. We have basis, will, and gift, or Hiba. Let's go through the rows. Row 1, effect. A will is after death. A gift is immediate. Row 2, consent. A will is limited by rules. A gift does not require it. Row 3, revocation. A will allows it before death. A gift is limited in this regard. Row 4, possession. A will does not require it. A gift absolutely requires it. I am explicitly ordering you to draw this exact matrix with a ruler in your answer booklet. Don't just write a paragraph comparing them. A drawn table instantly impresses the examiner and showcases your organized, highly logical understanding of the distinction between Wasiyat and Hiba.
Finally, your conclusion. The conclusion. The law of will under Muslim law balances individual freedom and protection of heirs. While a Muslim has the right to dispose of property, it is restricted by the 1/3 rule and consent requirements, ensuring fairness and preventing injustice. Use this strictly as your model summary paragraph for the exam. You must capture that exact phrase, preventing injustice. It demonstrates to the examiner that you grasp the underlying jurisprudential philosophy of these limitations.
As we wrap up this explainer, I want to leave you with a question to ponder. Since the 1/3 rule strictly protects legal heirs, does this rigid mathematical limit ultimately provide greater justice than absolute testamentary freedom? I challenge you all to think like true jurists here. While Western models often champion absolute freedom to dispose of property, Muslim law forces a deliberate balance. It literally binds the hands of the testator to protect the family unit. Reflect on this provocative jurisprudential thought regarding the balance of Muslim law before you walk into that hall. Review your notes, practice drawing that table, and you will excel in your exam. Class dismissed.